All right, I'm going to introduce our next keynote speaker in our series of keynotes, and that's going to take us from the district court and PTO interface and introduce another element to this, which is the International Trade Commission. We are delighted to have Shara Aranoff, the chair of the United States International Trade Commission, here to speak to us and then to join our panel afterwards. Commissioner Aranoff has a long and distinguished career in international trade, both in private practice at the law firm of Steptoe and Johnson, and in the International Trade Commission as an attorney advisor to the General Counsel. She has also worked in this area in the United States Senate. She was Senior International Trade Counsel on the Democratic staff of the United States Senate Committee on Finance, and then was nominated by President George W. Bush in 2005 to join the commission, which she now chairs, which is a rare and perhaps vanishing example of bipartisanship in the modern world. We are delighted to have her here. Commissioner Aranoff.
So just to correct Mark, I'm the former chair. I was chair from 2008 through 2010, and I'm currently, I was demoted to commissioner. But thank you very much. I really want to thank both Mark and Peter for inviting me to be here today. As everyone keeps reminding me as I walk around the room, technology companies based in Silicon Valley and your council here represent an important constituency for the International Trade Commission's intellectual property work. So as an agency, we really welcome opportunities to connect here on your home turf. And this is a great time of year to be in California, so thank you very much for giving me the opportunity to come out here. I do want to tell you from the outset that the views that I'm going to express today are my own. They're not necessarily the official views of the agency or of my fellow commissioners. It's to your advantage that I say that, because I'll probably be willing to say more than I might if I were strictly representing the whole agency. In the time that I have this morning, I want to do a couple of things. I want to orient you to the US ITC as an institution, because we're a little bit unusual. I want to talk about the origins of Section 337 and how it wasn't really originally crafted to combat patent infringement. As a background to the panel discussion, I want to compare and contrast patent litigation before the Commission as opposed to the district courts, and give you a bird's eye view of our caseload, how it's growing and changing. And then with all that background, I want to touch on some of the current hot topics in Section 337 practice that I know will be of interest. So the US ITC is an independent, quasi-judicial federal agency with broad investigative responsibilities on matters of trade. We're independent because even though we're part of the executive branch, the agency is structured to be immune from most political influences so that it can function in a nonpartisan and objective manner. And as Mark pointed out, we actually do achieve that bipartisan or nonpartisan atmosphere, which is fairly rare in Washington these days. The commission's made up of 6 commissioners nominated by the president, confirmed by the Senate for staggered 9-year terms. No more than 3 of us can be members of the same political party. The chairmanship changes every 2 years, and it has to go to a member of the other party. Our next chairman is going to take office in just a few weeks on June 16th, and we actually don't know who that's going to be. So the Commission has several distinct missions. We conduct classic trade remedy investigations under the anti-dumping and countervailing duty laws and the global and China safeguards laws. As you know, we adjudicate cases involving imports that allegedly infringe intellectual property rights under Section 337 of the Tariff Act of 1930. We also maintain the U.S. Harmonized Tariff Schedule. We provide objective economic analysis on international trade and competitiveness issues, and we provide trade policy support to the legislative and executive branches. So like the district courts, the Commission is effectively a part-time patent institution. In some ways, the Commission is also an accidental patent institution. Section 337 was passed into law by the Tariff Act of 1930, but its origins actually go back to the Tariff Act of 1922. And neither that provision nor its legislative history makes any mention of patents. In fact, the new law was intended to cover unfair methods of competition and unfair acts in the importation of articles that were not addressed by the newly minted Anti-Dumping Act of 1916. It was only later that a divided panel of the U.S. Court of Customs and Patent Appeals would rule that this predecessor to Section 337 could apply to patent infringement, although the dissenting judge did comment that if the word patent appears anywhere in the Act, it has escaped my search. So Congress clearly meant Section 316, that's the predecessor, to be a trade remedy. It required an act of importation and a showing that the imports in question were causing injury to a U.S. industry, just like in anti-dumping cases. If a violation was shown, the relief could be granted or denied at the discretion of the president, which is still the case today for safeguards cases. Once the law came into force, however, it soon became clear that the majority of the parties who were trying to use it were intellectual property rights holders who were trying to combat infringing imports. So this tension between the original design of the law and the way in which most parties wanted to use it would not be resolved for many years, and arguably it's one that continues today. There have been several rounds of amendments that resulted in the version of Section 337 that we know today. Importantly, in 1974, the law was amended to provide that Section 337 investigations are subject to the Administrative Procedure Act. The practical effect of that change was that the Commission went out and hired a corps of administrative law judges to actually hold the trials in these cases, which the Commission used to do itself. So these judges have gained expertise in the law and brought a heightened level of professionalism to the proceedings. A second change in 1974 was that the Commission itself could impose a remedy instead of leaving that question wholly to the President, although, of course, the President still has the ability to disapprove what the Commission does. Another major amendment came in 1988 when Congress eliminated the injury requirement for most cases. So now in cases involving statutory IP rights, which is most of our cases, the complainant only needs to show that a domestic industry exists or is in the process of being established and doesn't actually have to show injury. So through several amendments over about a 60-year period, Congress ultimately made Section 337 a more user-friendly vehicle for IP rights holders to seek relief against infringing imports. Nevertheless, the law is still properly considered a trade remedy because it requires importation of articles, it requires the existence of a domestic industry, because enforcement is performed at the border, and because cases involving unfair practices and other practices other than IP infringement, while rare, are still possible. So, although most Section 337 investigations are based on claims of patent infringement, those participating in their first Section 337 investigation may be surprised that there are a lot of differences between bringing a patent claim at the ITC and bringing one in the district courts. And as background for the upcoming panel, I wanted to run through what some of the key differences are. But before I do that, I want to remind everyone that with very narrow exceptions, the substantive patent law that the Commission applies is exactly the same as the law applied in district court. And the Commission's decisions are subject to review in the Federal Circuit precisely to ensure that conformity. The principal differences, though, are statutory. They're grounded in the language of Section 337. So first is jurisdiction. The Commission's jurisdiction is in rem over the allegedly infringing goods rather than in personam. That's why you'll see all our cases styled, named after the product rather than the complainant versus respondent. Second comes the importation requirement. The complainant must show that the allegedly infringing articles are imported. A very important distinction is the domestic industry requirement. While in district court, the complainant needs to only show that it owns a patent or other intellectual property right that it's asserting, a Section 337 complainant has to show that a domestic industry exists or is in the process of being established that relates to the articles protected by its asserted IP. The complainant can meet that requirement by showing a significant investment in plant and equipment, significant employment of labor or capital, or a substantial investment in exploitation of the asserted intellectual property right, including through engineering, research and development, or licensing. And I'll speak more about the domestic industry requirement a little bit later. The final statutory differences go to remedy. The Commission has no authority to remedy past injury through damages. The relief that the Commission can offer is prospective only through the issuance of a limited or general exclusion order that blocks infringing goods at the border, and through cease and desist orders that forbid the domestic sale of such goods by domestically based respondents. Section 337 states that the Commission shall exclude goods that it has found to be infringing from entry into the United States, unless it finds that relief is not appropriate in light of 4 specific public interest factors that are laid out in the statute, which are the public health and welfare, competitive conditions in the U.S. economy, the production of like or directly competitive articles in the United States, and U.S. consumers. There are, as many know, only 3 cases where the Commission has actually denied relief outright under the public interest provision. But maybe during the panel discussion, if it comes up, we'll get into why the public interest factors actually have a broader influence than that statistic might imply. Finally, even if the Commission decides that a remedy is appropriate, the President has the power to prevent the remedy from going into effect if he determines that a remedy is not appropriate for what the statute refers to as policy reasons. Policy reasons are not defined in the statute, and as a practical matter, there's really no limits on the President's discretion to disapprove a remedy that the Commission has put into effect. Nonetheless, while Presidents Carter and Reagan did disapprove a handful of cases, this has not happened recently. And there are some reasons for that, which also may come up in the discussion. So in addition to the statutory differences between Section 337 investigations and a district court patent infringement action, there are a number of procedural differences. Section 337 cases are tried to an administrative law judge with no jury, while a district court's decision can be appealed directly to the Federal Circuit. An ITC administrative law judge's decision cannot. Section 337 makes the Commission itself, which is to say the 6 commissioners sitting as a body, as the final agency decision maker. So ALJ decisions are reviewed by the full Commission, which can adopt the ALJ's decision in whole or in part, reverse it, revise it, remand it for further proceedings. Only after the Commission makes a final determination and after the time for presidential review has expired without disapproval in the event that there's been a finding of violation, only at that point can the decision be appealed to the Federal Circuit. As those of you who are veterans of the process know, despite this additional level of review, Section 337 investigations typically proceed much more quickly than a district court patent action. The Commission aims to complete all but the most complex matters in 13 to 14 months on average, and it's uncommon for a matter to extend past 18 months from final initiation to agency final decision. Speed may be one of the reasons that the Commission has a lower pretrial settlement rate than district courts do. Historically, about a 40% average settlement rate, although the number can vary significantly from year to year. A final difference involves Markman hearings, and this may come up in the panel discussion, which are used less frequently and somewhat differently at the Commission than in district court. The Commission has ruled that Markman orders are not reviewable by the Commission on an interlocutory basis, which means they can't be reviewed until after the ALJ has issued either a summary determination or his initial determination on the merits. So having talked about the basic structure of Section 337 investigations and their history, I want to give you a snapshot of where we are now, because really no discussion of 337 is complete without lots of statistics. So it'll come as no surprise to anyone that the caseload is growing, and it has been growing for about, well, more than 10 years now. In calendar year 2002, there were 17 new cases instituted. 5 years later, in 2007, there were 35 new cases, and in 2011, 4 years after that, there were 69 cases instituted. That's the high water mark so far. But the progression has not been steady. For example, there were 41 new cases in 2008, and then it went down to 31 in 2009. So what has been unprecedented has been the number of new filings in just the last 2 years, 56 in 2010 and 69 in 2011. I have to stop hitting that microphone. It remains to be seen if this is a sign of a continuing trend or if it's driven by particular events, in particular the many filings that have been associated with the ongoing smartphone wars. As the Section 337 caseload has grown, the Commission has really made a major effort to increase our resources that are devoted to its administration. And that's forced us to make some difficult choices in funding both our Section 337 operation and all the other things that we do that I mentioned at the beginning. In fiscal year 2004, the Commission devoted about 17% of its budget to Section 337. That was up from just over 10% back in the 90s. But by fiscal year 2011, it was 27% of our budget. We've gone from 4 to 6 administrative law judges, from 1 to 2 law clerks per ALJ. We've added Section 337 attorneys in our Office of General Counsel, which advises the Commission in the Commission review portion of the proceeding. And we're in the final stages of constructing a long-awaited new courtroom so that we can conduct more trials at the same time. We're also experimenting with new staffing options in our Office of Unfair Import Investigations. And as many of you know, OUII attorneys traditionally function as an independent party, litigating party in Section 337 cases. So our goal is to have them to continue to add value, but to do it in as cost-effective a manner as possible to conserve resources. The Commission's current caseload is heavily skewed toward patent cases involving advanced technologies. Based on a study of our caseload that was completed about a year ago, about 17% of our cases were in computer software and accessories, another 17% in wireless technology and mobile devices, 13% in semiconductors and circuitry, 12% in televisions and TV accessories, 11% in computers, video game systems, and camera software. So collectively, these categories account for about 70% of our docket. But, you know, it's not all smartphones and chips. There was recently a Louis Vuitton trademark case on handbags and luggage. It didn't get that much attention in the patent press, but it did get a really nice write-up in Vogue. We have a case on Invisalign braces. And for romance, we have a case on electric fireplaces. And at the risk of embarrassing everyone, including myself, I should mention the case Certain Kinesiotherapy Devices, better known as the marital AIDS case. I leave it to all of your imagination what sort of public interest issues might be presented in that case. So our cases are not only complex, but they are large, at least in terms of the number of parties and the number of patent claims that are asserted. A recent internal study of 142 cases, Section 337 complainants named an average of 6.7 respondents and asserted 36.5 patent claims. Now, that said, you should bear in mind that all of those things tend to narrow down before the case actually goes to trial. As this audience probably knows already, any party, domestic or foreign, is free to file a Section 337 case as long as it holds a U.S. intellectual property right and can satisfy the domestic industry requirement. So a recent internal study found that almost 3/4 of Section 337 cases are still brought by domestic complainants, which is to say that they're at least headquartered here. As for complainants from foreign countries, Japan is the clear leader, followed by Korea, Taiwan, and the UK tied for third place. Most respondents, about 2/3, are also from the United States, but among foreign respondents, China ranks first, followed by Taiwan, and we also see a number of respondents from Hong Kong, Japan, Canada, Korea, and the UK. So by now, you're probably thinking, okay, enough history, enough statistics, tell us about the controversial stuff. So by popular demand, I wanted to touch on some of the hot topics in Section 337 practice, and I won't be exhaustive because I want to leave some for the panel discussion. But the first topic that I wanted to touch on is e-discovery. The expense and the potential for abuse with e-discovery is a concern in all areas of patent litigation, including at the Commission. Reform of e-discovery is a stated goal of Chief Judge Rader of the Federal Circuit and the e-discovery committee of the Federal Circuit Advisory Council. The e-discovery committee has developed model orders for district courts and for the ITC and made a presentation on the model order in a visit to the Commission earlier this year. And the Chief Judge is far from the only person who has asked us repeatedly if we're doing anything about it. So I am able to report to you that the Commission does have an internal working group that has been hard at work studying all of the proposals that were received from the e-discovery committee. There's a proposal we received from the ITC Trial Lawyers Association, as well as the various local rules and model orders that are being used in the district courts around the country. And it is my expectation that the Commission is going to put something out for public comment on this in the relatively near future. So please do keep on the lookout for that, because when it happens, we will welcome everyone's comments. Next, on public interest. When I came to the Commission 7 years ago, the agency had not expressly invoked the public interest factors to deny relief to a complainant in over 20 years. And the conventional wisdom was that the Commission interpreted the factors so narrowly that they were almost never used. Now, I don't agree that that was ever really the case, and someday I'm going to write a law review article about why. But in the meantime, the public interest factors have become the subject of major attention, starting in the 2007 investigation involving baseband processor chips. In that case, the Commission ALJ had found that the complainant Broadcom had proved its claim of patent infringement against respondent Qualcomm with respect to certain chips that are used to conserve battery power in mobile phones. He recommended a limited exclusion order extending to the infringing chips, but not to the downstream products such as telephone handsets that incorporated the infringing chips. The chips in question were produced abroad, but they weren't imported in the form of chips. They were generally installed into cell phones at the time of importation. So consistent with its normal practice, the Commission sought comments on remedy and public interest at the same time that it took up the ALJ's violation decision for review. Now, in most cases, when we go out and ask for comments on the public interest, it's really perfunctory and we hardly get any responses. Usually a complainant will assert that there's a public interest in enforcing intellectual property rights. Okay. And a respondent may make no argument at all, or maybe they'll make a very generalized argument directed at one or more of the public interest factors that's not very well developed or supported by evidence. So in baseband, in contrast, we were really deluged with comments because a very large percentage of all cell phones for sale in the US market at that time contained the infringing technology. So we heard from mobile service providers that excluding phones with this technology would slow the build out of the 3G network. We heard from first responders that they would be hampered in their efforts to respond in emergency situations. We heard from content providers that they wouldn't have a platform to offer their music or other content services to mobile phone users. You know, these were important and serious arguments that went to the heart of the public interest factors and that we really were not used to hearing. But the problem was there was no factual record on which to assess them, because the Commission practice has always been that the administrative law judge can't take evidence on public interest issues unless he's been expressly requested to do so in advance by the Commission. And historically, that would only happen in about 1% of the cases where we would basically look at the complaint and go, this is a case that might have public interest issues. Okay, we'll ask the ALJ to take some evidence on it. So that had not happened in this case. It had not been flagged early in the case that these kind of issues were going to be raised. The result was that the Commission had to go back and make up for that. We held a 2-day public hearing. We had extra rounds of briefing to try and build the missing factual record. Ultimately, the Commission found that an outright ban of all cell phones containing the accused chips was not going to be consistent with the public interest, but that a narrower exclusion order would give complainant meaningful relief while maintaining public access to adequate cell phone choices. And as those who follow the case know, the President did not disapprove the Commission's remedy decision despite an active lobbying campaign. However, ultimately, the Federal Circuit reversed the Commission's decision, but on entirely different grounds. So my point in going through all this detail is just to underscore that historically many parties have treated the public interest inquiry as an afterthought, instead of focusing early on whether there might be evidentiary issues that could be developed before the ALJ. This creates a problem not just for the Commission, because we get to the end of the case and there's no record there to decide factors that it turns out are important, but it's also a problem for the U.S. Trade Representative, to whom the President has delegated his power to disapprove Commission remedies based on policy reasons, and USTR also relies on the record that's developed by the Commission. So the baseband processor's experience led the Commission to think about how we could do a better job identifying cases where we should be referring public interest issues to ALJs, and how we could elicit more robust and helpful input from the parties in all cases, even when we weren't referring them to the ALJ. And after a pilot program, we did issue new final rules in November 2011, which require the complainant to file a statement on public interest concurrently with the complaint containing certain specific information. Respondents and the general public have an opportunity to respond, and then the complainant has a reply. Those filings are in addition to opportunities to comment later in the case at the point of commission review, even if the commission has not referred the matter to the ALJ to take evidence. So during the 16-month pilot that preceded the final rule, the commission received comments on the public interest in only about a third of cases, which again suggests that the majority of our cases don't present serious public interest concerns. But during the same period, the commission referred the public interest to the ALJ in about 12% of investigations, which is obviously up from 1% prior to the new procedures going into effect. We don't know if these new procedures are actually going to lead to more exclusion orders being denied or being limited in scope based on public interest considerations. That was not necessarily the goal of what the commission was doing, although it is a possible result. And it wasn't the intent of the commission to signal a change in the way that the agency interprets the statutory public interest factors themselves. So really, this is all about improving the record and then seeing where that leads us. And that leads me to one more, everyone's favorite topic, which is the role of NPEs at the commission right now. After the Supreme Court's 2006 decision in eBay, some people expressed concern that NPEs, and in particular patent assertion entities, were going to rush to the ITC where they could still get injunctions or use the threat of an injunction to reach a favorable settlement. So I want to start by reminding everybody at the outset that the International Trade Commission is not a policy-making body, but rather a quasi-judicial one. So our job is just to apply Section 337 the way Congress wrote it. As such, the agency has no position on whether NPEs, PAEs, or their litigation habits are good or bad. So all I can really tell you is the facts from where I'm standing, and that's what I'm going to try and do. The main thing to keep in mind about NPE litigation at the Commission is that every complainant has to satisfy the domestic industry requirement. So typically, a patent holder that's not practicing the particular patent that's asserted will try to meet the test under Section 337A3C, which requires proof of a substantial investment in exploitation, including engineering, research and development, or licensing. Some commentators have argued that under this test, the ITC's doors are wide open to NPE and PAE cases. Others have argued that the bar is actually pretty high. So are these parties actually flocking to the ITC? I know some people have made that argument. I'm not entirely sure that the data, at least the data that we have internally, support that claim. So before going into the specifics, first it bears mentioning that the overwhelming majority of all patent litigation in the United States is conducted in the district court, not at the ITC. Over the past several years, there have been about 3,000 patent infringement actions filed every year in district court. In contrast, the number filed at the ITC has never exceeded 69. So that's less than 3% of US patent litigation occurring at the ITC. We do have a higher rate of cases that go to trial, and that's another matter. It's important to remember that the Commission's 337 caseload began climbing long before eBay. Public data from the Commission website show that during the 5 calendar years prior to eBay, the average number of new cases was 23. In the 5 years after, the number was approximately twice as high at 46. But if you go back to the period 96 to 2000, which is the 5 years before the 5 years immediately before eBay, the number was 13. So while eBay may have a role in the rise in our caseload, it's clearly not the only factor. And in fact, the big jump in filings that we've seen didn't happen until 2010, which was fully 4 years after eBay. So rather than looking at overall filings, some people have tried to count only the filings by NPEs and PAEs at the Commission. That's, of course, an exercise that's hampered by the fact that there really aren't any generally accepted definitions of who these parties are, and so there's always going to be some kind of subjective judgment calls involved in how it's done. And of the sources that I have seen out there, some of them have not made public their classification methodology, so it's hard to then go back and independently verify the figures. Our staff at the Commission have taken a look at all the Section 337 complaints filed since May 2006, the date of eBay. The numbers are still being reviewed internally, but I can share with you what we know so far. Our staff have not had time yet to look at the filings before eBay, so we can't yet do a before and after comparison to tell you if filings by NPEs and PAEs have gone up. Staff used the definition of a patent assertion entity that was used by the Federal Trade Commission, that is, a company whose business model rests exclusively on purchasing and asserting patents. And then they made a call on how to classify complainants based on the legal basis that they asserted for their domestic industry in the complaint, and information about the complainant's business that was contained in the complaint or in the agency record. Here's what we found. Out of 258 investigations instituted since eBay, 8 were brought by PAEs, another 8% were brought by PAEs, another 10% by NPEs other than PAEs, for a total of 18%. So the vast majority of Section 337 cases are brought by entities that are neither NPEs nor PAEs. In addition, the top year for combined NPE and PAE complaints was in 2009, when they were about 26% of all complaints filed. In 2010 and 11, they were 18 to 19% of all complaints. So our staff also studied how often NPEs and PAEs prevailed in the case and obtained exclusion orders. Since eBay issued, only 2 NPEs and 1 PAE have won exclusion orders in front of the Commission. The other thing staff looked at is settlement rates, to look at the issue of whether or not these types of entities are using the Commission to extract settlements from respondents. It's difficult to evaluate whether settlements involving NPEs and PAEs are qualitatively different from settlements that are achieved before the Commission by other complainants. But in terms of numbers, you would expect that if those kind of entities want to use the Commission process to extract settlements and aren't that interested in actually having a remedy at the end of the process, you would expect to see a significantly higher settlement rate than our average settlement rate for all cases. Our data show a settlement rate of 38% for NPEs, 62% for PAEs, 51% for other complainants. If you combine NPEs and PAEs, the settlement rate is about 47%. You can make what you will of these data because our sample size is obviously not that large. So more study on the issue is welcome. My personal view is that the predictions about how eBay would affect the 337 caseload haven't really been borne out in the data. There may be something there. No matter what the data show, what is perhaps more important are the perceptions of counsel advising their Section 337 clients. In the past few years, the Commission has decided several cases that address the domestic industry requirement that are relevant to non-practicing entities. And you know those include the stringed musical instruments case in 2008 involving an individual investor, coaxial cable connectors in 2010, involving the treatment of district court patent litigation expenses in establishing a domestic industry based on licensing, and the multimedia display and navigation devices, the GPS case in 2011, which involved licensing expenses associated with patent portfolios. So in none of those cases was the complainant found to have satisfied the domestic industry requirement. And in light of those developments, I'm hoping to hear from the private practitioners on the next panel whether the advice that they would give an NPE or a PAE client today about filing in the ITC is the same advice that they might have given immediately following eBay. So before I conclude, I do just want to also mention what I think of as the elephant in the room. It's maybe a different elephant than was referred to earlier this morning, which is draft legislation that many of you may have seen that was recently proposed to amend Section 337 in a number of ways that would relate to domestic industry, public interest, and remedy. So because the Commission is not a policymaking body, the agency doesn't take any position on the question of whether Section 337 needs to be fixed or whether this particular draft legislation represents the best way to do that. But I would note that Congress has a history, as I pointed out, of periodically revisiting Section 337 and amending it to reflect the times. So there's no reason that that pattern shouldn't continue. The Commission's job in any policy debate is to provide objective information about our Section 337 caseload and our practice. That's what I've tried to do today, and it's certainly what the agency stands ready to do if any legislation starts to gather steam. There's such a wealth of topics on practice in 337 that it's hard for me to limit myself, but I am going to stop here. And I'll enjoy hearing what the next panel has to say. Thank you.